you are in chapter 210 for today, correct? Chapter 210?
Yep.
Has anybody started reading the cases yet? That's all right. You didn't need to read the cases. I just want to go through today, not only 210 in respect of petitions to dispense with parental consent to adoption, but let's compare it to what we've talked about so far, the care and protection proceedings, okay? So, and that way we can summarize not only what you've learned about care and protection, but moving forward to the more serious, obviously, petitions for adoption, petitions to dispense with parental consent. So that being said, I'm asking for volunteers to describe the care and protection process. Who wants to start?
Okay. There are mandated reporters, such as pastors and teachers, and if they see signs of abuse.
Stop. Just jump ahead.
Okay.
You're starting way at the beginning at a 51A report. Let's talk about the court proceedings. So a care and protection petition, first of all, is governed by what statute? Not the statute you had to read today, but
119.
119. Okay. Yeah. So what else can you tell me, Dita, about care and protection?
Once the 51A is supported and then the 51B investigation is done.
Get all that.
What do you want me to start from?
From the
the
filing of a care and protection petition. Who files, Lester? What agency have we been dealing with for the last month?
DCF worker.
Yeah.
DC, yeah. Thank you, class. Who files the care and protection petition? Even though, I mean, technically, and it's okay that you hesitated because the statute does say any person. But for purposes of probably 98% of the cases, and the cases that you've been reading thus far, it's DCF, it's the Department of Children and Families that files the care and protection petition, right? And so if you had to summarize what the reason for filing a care and protection case is, Jadita, since you started.
The reason for filing?
Yeah.
Well, I would have to say because there were clear signs of abuse, and the children, the department has to find their best interest in placing them in a situation where.
What's the reason for filing?
To put in the central registry.
Supported 51A.
Well, it's interesting that you say that because, and I've said this before, just because, and look at the hypothetical that we did last week, right, the mental neglect. Just because a 51A is supported, and maybe many 51As are supported for a family, it doesn't mean the department's going to be running to court to file a care and protection case, right? All 51A is merely just a report to DCF, right? DCF being an agency that helps families, offers services, etc., could be offering services, but maybe is not going to court to file. So my question was, why and in what context generally would the department be going to court to file a care and protection case? Because they don't have a hand up
For
first.
the safety and health, the welfare, safety, and health of the child. When that's been compromised in any way, and they feel that they need the court to act on their behalf.
Okay, that's one way to put it. Asher had his hand up
I
too.
was going to say if there's a substantial risk of evident or serious bodily injury to the child.
Okay. Bridget?
If they find clear and convincing evidence.
Not yet, because that's a burden of proof later on when you get to trial. Okay, so hold on to that thought. And here's an even easier answer. Look at 119.24, the first paragraph. And I'm just going to read some of it to you verbatim. A person, remember Lester, I said anybody could, but it's mainly the department, may petition under oath the juvenile court, alleging on behalf of a child within its jurisdiction that the child is, and then there's A, B, C, D. And it's generally all of what you guys just said. A, the child is without necessary and proper physical or educational care and discipline. That's A. Physical or educational care, A. B is growing up under conditions or circumstances damaging to the child's sound character development. So that's a different type of, for example, the domestic violence, perhaps, viewing domestic violence in the home might fall under B. C, lacks proper attention of the parent guardian, lacks proper attention of the parent. So, for example, neglect might fall under C. Or has a parent, again, guardian, custodian, blah, 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 who is unwilling, incompetent, or unavailable to provide such care, discipline, or attention. Unwilling, incompetent, mental health, medical neglect, alcohol abuse, etc., drug abuse, to provide care, discipline, or attention. And those are the general allegations, right, of a care and a care and protection petition under 119.24, and we've gone through, the standards and all of that for a care and protection case. Everybody's looking like they're hearing this for the first time, but you're not, right? It's just a review right now. Okay. So what's the intent of DCF in filing, again, something like this? What are they looking to do? What are they looking to get?
To get temporary or permanent custody,
Yeah.
depending on the case.
Yeah, so because of these, insufficiencies of the parents that might be temporary at the time of the filing, DCF is looking to get custody in a care and protection case, right? Temporarily, from, if it was an emergency, or from the first temporary custody case, and then at trial, perhaps, permanent custody as well. What is the worst case scenario? No, wait, before I ask that question, Richard mentioned before something about clear and convincing. So, care and protection case that goes to trial, what are the issues? What is the issue at trial generally?
If there was enough evidence to support the allegations.
If there was enough evidence to support the allegations, take that a step further. What legal conclusions would the court be making, Lester?
Termination of parental rights?
Not yet, because we're only talking about care and protection cases right now. And we'll talk about them in terms of the distinction between, and possibly termination as well.
Clear evidence that the parents will be unable to provide for the necessary needs and care for the child.
Okay, all right. What's the standard? Clear and convincing evidence of the parents' what?
Unfitness.
Unfitness. Clear and convincing evidence. Unfitness, right? And it's not just unfitness, but it's at the time of trial, suppose I was drunk all the time. And then, by the time the case went to trial a year later, I've been going to AA meetings, I have a full-time job, etc. Does it matter that the allegations back when the petition was filed a year or so ago were so horrendous about me, if at the time of trial, right? So it's current, right? So the court looks at current parental unfitness. And so if a parent loses a care and protection case, what does that mean?
That there's evidence of neglect
Certainly, yeah, and that the child is adjudicated in need of care and protection. But what does that mean legally for the parents' rights? Jeremiah?
If they're found unfit,
Right.
then.
So you have two children,
At first, temporarily, their parental rights have been suspended or whatnot. And then according to one.
You have two children, Al and Joan.
Then they're taken into custody by the
And so they've been
state.
adjudicated in need
Right,
of
if
care.
their parents are found unfit, then the state takes temporary custody of those two kids.
Or permanent.
Or permanent. Well, yeah, depending on the heinousness of the charges, I would think, according to just section 1 of 119, it seems like the state's goal at first, again, depending on the heinousness, would be to get the parents the resources they need to become correct parents and get the kids back, reunification. Or you're so screwed up, you never get the kids back, and the state becomes permanent.
Okay, but you've lost, the day of trial is over, right? And the judge has, actually the day is over, but it doesn't mean that you have the decision yet, because actually the judge has a very big job to do, because it isn't just, for example, a contracts case, you have, judgment for plaintiff, a one-page thing. The judge has to actually write very detailed findings of facts, rulings of law, to back up the decision adjudicating children, in need of care and protection. So you may know the decision earlier, but it takes a while to, get the actual written report. But what I'm asking is, on the day or thereabouts, you represent parents, or children, whatever, and you know that they've lost the case. What does it mean legally for the parents?
The parents' next step would be to file an appeal of the juvenile court's decision through the appellate court.
True.
Talking like physically, like the kids are walking out the door with the state representative?
Yeah, and they've already probably been in foster care. And Jeremiah, they're probably not there, because remember we talked about in a care and protection case, children only have to be identified once, and they're not generally, brought to court. And you guys have all told me that it's about custody.
Right.
So if it's about custody, the care and protection trial has occurred, but that's what I'm trying to get you to the next step. Is anything else still going on legally? Remember we have the agency as well as the court. Yeah.
You mean the parents might also be embroiled in their own legal matters?
No. What's going on with the care and protection case itself?
The parents could try to modify, if they had temporary custody, they could try to get permanent custody back or get custody back.
All right, say it's permanent custody. I make an easy question here. It's permanent custody that the department has. Where are the children? Foster or relative or pre-adoptive even perhaps. Where are the parents? By themselves, whatever. Do the parents?
Probably in court.
Now they go for revisitation.
What's that?
You say now is where they fight for visitation.
Do they have to fight for visitation? They've just lost custody.
They're not going to be given it.
They're not going to have free and ready access to the kids if they don't have custody of them. So.
What is the definition of custody?
Decision making.
Decision making. What else does it say?
Possession.
I'm sorry?
I said possession, but that's not the right word.
When DCF has custody,
Responsibility for.
they can control visits to the all right? They can control visits. Visits aren't over unless, remember we read the custody of a minor case. Unless parental visits would be harmful to the child, unless the court had ruled that would be the case. Parents have just lost custody only. Yes, that's very serious because parents, as Jeremiah said, are living somewhere else, and, but they've only lost custody, not parental rights. Therefore, they would, if there was a visitation order in place, or maybe there's a new one, maybe it's supervised at DCF offices, or maybe it's with this relative, or whatever it is, visitation could and does still occur. Services still occur, okay? The DCF has not closed its file on this family after this trial is over, because DCF has custody. Even permanent custody just means that DCF has custody. Legal rights to the child, control visitations, sign enlistments, things like that. Preparing, maybe at that point, a new service plan for the family. And that new service plan may go to something more permanent, and we're gonna talk about that soon, but I just wanted to get this part clear for you guys in terms of review. Jadida?
Okay, so you just said that the parents haven't lost their rights. It kind of confused me, so I just want to
Right.
make sure I understand it. So
They've only lost, let's put it this way, use the term custody. They've lost custodial rights.
so they can still make decisions as to like.
Custodial rights, what does legal custody mean? It does mean that you're making decisions, all right? It doesn't mean that you've lost the right to be a parent of that child,
That's what
right?
I'm confusing myself. Yeah. Okay.
You haven't lost that constitutional right that we talked about earlier in the semester to be a parent of that child. And because the case is not over, and we went through those, those 4 allegations in the petition, and any of those 4 allegations, in terms of the parent's fitness could be changing, right? Could be changing.
So I've lost custodial rights, but I still have parental rights. What does that give me?
Good question. What does that give you? So suppose that it's now, children are in foster care. DCF is, allowing you to see them. You're seeing them. DCF is offering services such as, some particular type of counseling that you're going to for whatever your condition is. You're doing that. You have a better job, a better housing, again, whatever the services, whatever the service plan is looking to do, you've complied, all right? And now, so it's 3 months post that 11926 order of permanent custody. 3 months post-trial. What can you do? Bridget?
You could, I'm assuming, you could oppose like the placement of the children. They're in foster care right now. You could come and say.
Even
listen,
more than that.
You can try to get them back.
How do you try? Jadida just said try to get them back.
You can show all of these things that were against
How?
you, for example.
What do you do under the statute?
Oh, you have to. I forgot what it's called.
And this will become clear when we get to the termination piece, where you won't be able to do these things. Jeremiah?
You work with the agency to get yourself qualified to get care of the child.
Say that again?
You work with the agency.
You've done that, okay?
Yes,
And
sir.
so now, so you're calling up your attorney and you say, what can I do now? I've done everything they've said.
So you go back to court.
Yes.
And have them show me that you're qualified, have the court say you're qualified to get care of the child.
You know what it's called, Jeremiah? And it's
Well,
in
I'm reading-
section 26.
Yeah, I'm reading it, it's section 26(2)(I). It just says,
It's review and redetermination.
Oh,
Do you
yeah.
see that anywhere?
Yeah.
Okay. So you're back in, as Jadida said.
You file a petition.
Yeah. You're looking for review and redetermination under the current petition. You're petitioning for review and redetermination. A, B, C, D, E, F, I've done all of those. So that's what I meant when I said you haven't lost parental rights. There's still a possibility, depending on the circumstances. Under 26, it's by a party filing. And also under 29B, the court itself holds annual reviews when children are in foster care. The department itself also holds foster care reviews when children are in foster care. So it's not over in terms of parental rights if it's a care and protection case where DCF got custody because parent was currently unfit. Richard?
Could you just differentiate between the review and termination under 26B and a permanence hearing under 29B?
The 29B is automatic. The court just holds it yearly, annual reviews, 29B. 26, again, is by petition of party, and usually it's, a parent, review and redetermination. I'd like you to look at this case again, Judge. You found me currently unfit, 3 months ago, 6 months ago. That's not the case today. Okay, so how is 210 different from that? And let me just give you a little bit of history first, and that's the reason why I wanted to outline the care and protection process by itself first. Until 1992, that was it in terms of juvenile court. Parents only could lose custody. A juvenile court could not terminate parental rights. That used to be the jurisdiction of the probate and family court only.
Until 92?
Yeah, and it was the Acts of 303, the legislative. Back then, the department obviously does the service plans, meets as an agency, and makes decisions about, families. So, when the department would change, interagency, its goal to adoption for many reasons, basically, generally, because parents would always be unfit in a particular case for whatever, again, for different reasons. Even when a care and protection case was still open, if that became the goal, and if it was DSS back then, if DSS wanted to terminate parental rights, they had to go to probate court, probate and family court, and file a petition under Chapter 210, Section 3, to dispense with parental consent to adoption. And what really got tricky about those cases is because I just said, even if the care and protection case was still open. So the care and protection case maybe had not gone to trial or any kind of disposition yet. But DSS said, you know what? We need to free up this kid or these kids for adoption. They need permanency. These parents, for whatever reason, are always going to be unfit. But they couldn't do anything in the juvenile court. They had to go to probate and family court. But they couldn't dismiss the care and protection case because that was still open, right, as to the parents' unfitness. It got even crazier because attorneys would be appointed in the juvenile court. Other attorneys would be appointed in the probate and family court. So it got really crazy for a while. And then ultimately, at some point the CMP, resolves itself in some way because the adoption petition, moves forward and that case either goes to trial or gets disposed of in some way. There was at one point another legislative change that actually allowed these cases to get consolidated and allowed, for the most part, the CMPs to be heard together with the 210s, usually in probate court. So that was one attempt at, sort of, it's about one family. It's about one set of kids with, one set of parents. Why can't we do this in one court? So that, they attempted to do it that way. And as I said before, in 92 was the big change. And it was the big change for, many reasons. Where unfitness and, parents, for example, look at the allegations of 11924 for whatever reason, unsuitable temporarily, and that's the reason why DCF goes and files to get custody, and that was always the focus. But with the new changes in '92, the ultimate sort of focus became the health and safety of the child, the best interest of the child. And so the legislature decided that if DCF had a goal of adoption and termination, that they could do that in the juvenile courts. And they could do that from the beginning of a CNP case. They could do it during the pendency of a CNP case. They could do it at the end of a CNP case. A judge could decide it at the end of a CNP case. And so 210 section 3 in the very first paragraph mentions the best interest of the child standard. And it says whenever a petition for adoption is filed by a person, again, typically it's DCF, even though it says a person, having the care or custody of a child, the consent of parents, because it talks about persons, shall not be required, and it talks about, of course, if you're 18 years or older, that doesn't, the consent is not required. But the one we're talking about is the court hearing the petition finds the allowance of the petition is in the best interest of the child. And so, the statute provides that the juvenile court shall enter a decree dispensing with consent. Upon a finding that the parents aren't, so they still have, the court still has to make the underlying finding, right? That the child is in need of care and protection pursuant to this section 26. And that the best interest of the child is served by that particular decree. And again, the statute states, as I said before, that the facts might be set forth when you first file the care and protection petition, if that's the department's goal from the beginning, or upon a motion during the course of the care and protection case. So it's never really a surprise to the parents. Remember when we first talked about care and protection petitions, and we talked about the notice to the parents? The notice that they get with the care and protection petition says this may be a case where your consent to adoption is dispensed with according to chapter 210 section 3. So it isn't as if, oh, surprise, the department is looking to terminate your parental rights. You do get notice along the way or from the beginning.
But is it standard notice that everybody gets, or just in
Yes,
cases where they
yes.
think it may happen?
I'm sorry, good, I'm glad you asked the question. Two things, one is the standard notice. One is the standard notice when DCF files the petition and you get your notice. Okay. The other thing that I was talking about, Pat, is when the CNP is sort of ongoing, you know, the DCF has service plans. At some point, new service plan is done, and the new service plan now is not reunification, but termination. And so they might be going in a motion, or DCF attorney is calling parents' attorney, DCF social worker is also telling parents, we're looking for adoption here. So that's what I meant when I said, you know, there's no surprise. It isn't like you go to trial and suddenly the judge, you know, decides to terminate parental rights. Now, in the statute, there's a few instances when it's mandatory for DCF to do it. And it's in section B, I'm sorry, 1, 2, 3, 4th paragraph. Here's instance 1, the child has been abandoned, so DCF has to file.
Where is that?
4th paragraph of 210, section 3, part B, 1, 2, 3, 4th paragraph, that starts, the Department of Children and Families shall file a petition.
It comes right up.
Okay? If the child has been abandoned, so DCF then has to do a 210, section 3. Number 2, or if the parent has been convicted of some pretty serious charges. One is murder, voluntary manslaughter of another child, or an assault constituting a felony which results in pretty serious injury to that child. So again, very serious cases. And then 3 has to do with time. And that's perhaps one of the saddest of all, and we'll talk about that when we get to the adoption cases. If the child has been in foster care for 15 of the preceding 22 months, the statute says the DCF must file under chapter 210. So if the child is in foster care for 15 months, there's exceptions. If the child is, with relatives, the department doesn't have to do that. But those are the 3 instances where it's mandatory for the department. The abandonment issue, I'll just call it the felony issue, and the 3rd is the timing issue. Okay? Yes.
Sexual assault of one of the parents'
You
children.
say it louder so they can hear it?
Just sexual assault of one of the parents' children is going to force DCF to file a petition?
Mandatory?
Yeah, well.
Technically, it's funny that you said
let's say
that.
it was child rape.
Right.
It would be a felony, so would that count?
They're gonna do it under that. Is it technically under this mandatory language? Any assault yes, absolutely, yes, yes. If we have time, we had a really interesting issue, you just reminded me of something, of, come up in, I'll hold off on that case because it has to do with, child sexual abuse that we talked about before, but, I'll bring it up if we have time. Now, section C does shed some light on what fitness is and what best interest is. And then also in section 3, the most important, what we call the 14 factors are in there. So I'm gonna go through section C in quite detail right now. If you have the statute in front of you, fine. If not, just take some notes and go back to it. So section C, so 210, section 210.3, subsection C is what I'm looking at right now. So in determining best interests, the statute is telling us that the court looks at the ability, capacity, fitness, and readiness of the child's parents. And then also considers the ability, capacity, fitness, and readiness of the petitioners. Let me just say that there's 2 parts to this 210 process. DCF is A, looking to terminate parental rights of a certain set of parents, and B, DCF is usually proposing proposing adopted parents as well. So the probate court and or the juvenile court, not only terminates parental rights, but also looks at the proposed adoptioners as well. So there's that health and safety standard that I talked about earlier. The health and safety of the child shall be paramount but not exclusive concern.
Does it help in the termination of the parental rights when they're saying we have a solution and we have another family, like a foster family that's ready and
Yes. And that's pretty much what DCF is doing when they're doing the 210 section 3. Because the whole reason for that 1992 legislative change, you know what used to happen? Frankly, these parent protection cases in juvenile court, they hardly ever went to trial. They just stayed open for years. And we would just, we talked about going in for status conferences. We just keep going in for status conferences, and DCF would have kids in foster care, and there'd be the report from the social worker that said how the kids are doing, or what the parent is doing or not doing, and the cases never went to trial because nobody pushed for the cases to go to trial, because parents, for the most part, were unable, unwilling, etc., to do so. So the legislature, in its wisdom, love saying that. Sometimes sarcastically, sometimes not. Said, you know what? This is too bad. If parents are going to be like this forever, then the children need to be adopted. But it's interesting that you say that, Ashraf. So technically, both should happen. Doesn't always. So you could have termination, and kids could still be in foster care with no proposed adopted parent. So that is possible and probable in many cases too. So the court looks at, and I want to go through these factors. One is about abandonment. And by the way, the factors have to do with the fitness of the parents, but also best interest of the child. Look at factor 2. And a lot of the factors talk about services. The parents who are offered or received services intended to correct the circumstances that led to the abuse or neglect, and refused or were unable, the statute says, to utilize the services in order to correct the original circumstances of abuse and neglect. Now, what does that mean? And how would DCF be showing that? Richard?
If they order like parenting classes, the parents could either not go to them, that would be grounds, or they could go to them and they're not able to make the changes that the parenting class should teach them how to do or behave.
What else? Anybody think of another example?
Or they just didn't make satisfactory progress according to the presenter of the program.
According to the DCF,
Right.
the worker notes, etc.
Or like if the mom had a boyfriend that was abusing the kids and she doesn't want to put him out.
And say the service plan
Right.
said,
That he has to be put
this
out.
is what you should be doing.
Right.
That's what it comes down to, isn't it, the service plan?
It comes down to the service plan, and not complying with the service plan. But do you see who's in control here?
Parents.
You think so?
No, the department.
John? Come on, disagree with them, so you're gonna be on my side.
So, it seems like that type of if the DCF doesn't get precisely what their goal is, if they don't get that met or something towards that met, an improvement, it's their call to make it, that the goal isn't met, I think.
Well, that's the thing, assuming the service plan is reasonable,
Yeah.
like what you're saying, if the mom's dating an abusive boyfriend and she refuses, he refuses to get counseling and she refuses to quit, look, to me, that power's in control of the mom.
Cassandra?
Either way, whether the service plan is, either way, there's control over the mom, because if they're telling you to change some part of your life for the betterment of you and your child, and you having the chances of getting your child back, it's still control, because they're saying, listen, this is what you need to change. But at the same time, I would say that the parents have control as well, because then if you abide by these changes and you listen to what they're telling you, then it means you'll get your children back, and that's the main focus.
Can you think of examples where parents might actually be unable to follow through with a particular service that's offered?
Either mental illness or addictions.
Okay, be more specific about that.
Mental illness is they're not capable of.
There's actually another factor for that later on. You're saying that despite it's the condition of the parent. But
Right, and
okay.
that makes it impossible
Yes,
for them to comply and
Right.
satisfy the
Okay.
requirement.
Yeah.
From my experience, I'd say the hardest thing is parents who, they don't have enough resources.
Yes,
A lot of
that's
our
what I was thinking
parents, yeah, a lot of our parents, they're either homeless or they don't have jobs. And so a lot of times the court will say, okay, well, in order to get Sally and John back, you need to have an apartment, you need to have employment, you need to go to your, and the thing is, they're like, but I'm homeless, I have no resources. So a lot of times we would have to start from scratch.
Who's we tell the class
Oh,
you work
like
with,
the
Sandra?
agency, because I was a social worker, we would have to find them a housing, like a homeless shelter,
Mhm.
and then transition them from the homeless shelter to like halfway houses, kind of,
Mhm.
and from halfway houses, go through the state and get them, it's vouchers, it's like living vouchers, so that they can get Section 8 or they can get low income houses.
Okay.
And then we would have to get them food stamps and social security, like those benefits, like food
Exactly.
stamps and whatever. And then from there, put them into programs where they could get some sort of educational training or vocational training.
Right,
So that they could
right.
get a little job and then show that, okay, I've done A, B, C, and D, but it's still a long process to get them there. So that's sometimes the hurdle, like, wow, what you guys want me to do, I'm from here. I'm starting at 0, but you guys really want me to be, on level 5, and it takes a while. So that's the hardest
Good,
thing.
thank you.
Yeah.
Tim has his hand up too.
Oh, no, I think I was off on that, yeah.
Come on.
I just didn't know if you were talking about if they had like a criminal proceeding going on too. That
Yeah, go
kind of
ahead.
thing.
If-
Just not being able, I remember some of the cases had to admit to the abuse.
About the lead case that
Yeah.
we,
Yeah.
offered services to correct the circumstances,
Yeah.
but he
You can't
wasn't
admit
able
to it if he's already in
I
criminal
can't go to
case.
counseling because then I'm gonna be admitting,
Yeah.
yeah.
See, good point.
And to just follow up with Cassandra's too, poverty in and of itself can't be, the reason for finding a parent unfit and for, termination, et cetera. But suppose it's, your therapy is on such and such a day,
Right.
and you can't get there, or visitation, you can't get there.
Yeah, and a lot of the parents
And-
who had to start from scratch of rebuilding their lives,
Mhm.
they would miss out on visitations, and because they're trying to be on the
Exactly.
welfare line and try to go for housing and try to do this, they have so much to do that they miss out on a lot, so it becomes a double whammy.
Yeah. Here's the second one.
Does the court look kindly on situations like that? Do they realize what somebody's predicament may be and?
Well, what the statute says, Patricia, the court shall consider without limitation the following factors. So the court has to consider the factors and if the factors apply, they're going to be applied in terms of the best interests of the child, that for, these particular specific factors, maybe in the best interest of this child or those children, that the moms and or the dad's consent to adoption should be dispensed with. Then the next one deals, and some of these deal with time, the next 3 deal with timing. So the department has custody for 6 months, and in that time period, the parents have not maintained worker that
Yeah.
you're butting heads with right from the beginning.
Will they reassign you?
Well, a lot of times it's not the social worker that they have issues with. It's sometimes the foster parents. Because, you know, you have to cooperate, the birth parents have to
Yes.
cooperate with the foster parents to have visitation.
Yes,
And a
if
lot
it's
of
gonna be
times
coordinated that way and
yeah.
not supervised.
Right.
Yep.
And a lot of times they have issues.
Mhm. Now, the next two deal with the child being a certain age. So we're on, factor 4. The child is 4 years and up. Okay, 4 years and up. And the child has been in the custody of the department, I'm sorry, I always mess this one up. 12 months of the preceding 15-month period. And during that period, the parents were offered the services. Again, most of these factors go back to the services issue, and were refused or were unable to, to correct the services. So 4 years and up, we're talking about a 12-month period, and then when you go to factor 5, it's under 4, and we're talking about a 6-month period. And then when we go to factor 6, the parent, without excuse, it says, fails to provide proper care or custody for the child. And then there's a reasonable expectation that the parent will not be able to provide care or custody in the future, and again, in terms of the services afforded the family. 7 is another factor that we see a lot when we have foster parents or pre-adopted parents that have had the children for a long time and really love that child. The child loves them. They bonded with the foster parent or, again, pre-adopted parent. And the factor says because of the lengthy absence of the parent. And again, it goes back to, is that lengthy absence on purpose? Or is it, because of faults of the department? But anyway, the factor says the child has formed a strong positive bond with the substitute caretaker. And the forced removal would cause harm, serious psychological harm to the child. So again, that's one factor that could be, one of the reasons for termination. The next factor, 8, deals with a lack of effort by the parent to remedy, whatever conditions cause the abuse or neglect. They're calling it, generally speaking, any lack of effort. And again, that typically does go to not complying with the service plan. 9 deals with severe, and this would go to the sexual abuse case that we did. Severe or repetitive conduct that's physically, emotionally, sexually abusive, severe neglect toward the child or toward another child in the home. So that, something that's really of a severe nature may be one of the factors for termination. And then the next 2 deal with, is this something that a parent supposedly does on purpose? The willful failure to visit the child. It is 10, and then 11, the willful failure to support the child. 12 goes to what Patricia raised earlier, the condition which is reasonably likely to continue. Alcohol, drug addiction, mental deficiency, mental illness. And because of that condition, the parent would not be able to care for the child. You guys mentioned criminal convictions before. 13, the conviction of a parent of a felony. That's such a nature that it's going to deprive the child of being in a stable home for a period of years. But the statute says incarceration in and of itself can't be grounds for termination. But it's still a factor. And then lastly, the 14th factor, whether there's been a prior pattern of factors, and if the judge at a parental termination trial does dispense with the consent to adoption of the parents, the judge has to refer to all of the factors that the judge has relied on in order to rule that the best interest of the child would warrant termination of parental rights. So this is, except for appeal, as Richard said before, this would be final if at the conclusion of the Section 26 trial, 1926 is, remember, the trial section for your care and protection trials. If at the conclusion of the trial, the judge now issues the worst possible disposition, and that it's in the best interest of, Tommy, Jane, and Joe, that their parents' consent to adoption be dispensed with, the judge has to back it up. And it's backed up with, not only the general findings of fact and rules of law, but it's with these particular factors. And again, except for appeal, 3 months later, 6 months later, a year later, there's nothing. The case is over in the juvenile court. The case is done, it's over. Parents have lost parental rights, no visitation, no nothing. Now, there are sometimes instances, and we call it, the open adoption case, or some form of post-adoption communication, that either but it's usually with some negotiation between the parties, between DCF, and the parents' attorneys and the children's attorneys. But, other than that, parent has no parental rights whatsoever. And if the court then proceeds to the Part B, part of the adoption case, and approves the new adopted parents, those parents now have all of the parental rights that the previous bio parents had. Questions? Sandra, you look like you have a question.
I know when we talk about parents, we're thinking of adults, but I've had a foster child on my case who was a parent and
Yes.
lost her rights. But what was interesting is she was 16, 17, and her rights were terminated.
Mm-hmm. Do you know if she did a voluntary surrender, or were her
No,
rights
that's-
terminated after a trial, or
And she didn't go to trial.
she must have did a voluntary surrender? Because, you can, everything we've been talking about from the beginning to the end can be waived, right?
But that could be a problem if you're a foster child, if the foster parents don't want you to have that child, that's an issue as well, your placement.
Yes.
I'm not even sure what kind of placement
Sure.
they have, it's an emancipated
Oh.
minor at that point, but,
Yeah.
I don't know.
Those voluntary surrenders are so final. I had a case once where the girl came to me like within 24 hours after she signed it. My God, I made it. We could not get it reversed. We could not get it reversed. Absent, somebody almost forcibly making you sign. And again, absence, mental illness or, reasons like that.
But I remember she wanted to fight it because she said that she was almost 18, she was almost out of foster care, and that she'll be able to provide for the kids. But then I don't know who that was encouraging. There was someone that was encouraging her to sign the voluntary, to release her rights because she was in foster care and she wasn't really doing so well. But yeah.
So you don't know if
She
in
lost
fact-
them. She lost them. She
Okay.
lost her rights, I mean.
Any questions about the process, because we'll get into the case law on Thursday. So when you're looking at, by the way, either the course of your research for, if you're working for an attorney, or even some of the cases that I've older cases, what was I saying? The older cases deal with, obviously, DCF going just to, to probate court to terminate parental rights under chapter 210. And a lot of the newer cases are cases that originated in a juvenile court as a care and protection case that became a termination of parental rights as well. Or some of the cases where judges have gotten reversed have been exactly that. Care and protection cases that went to trial on the issue of termination as well, and the judge, not only found the parents unfit and adjudicated the children needed care and protection, but then went the next step and also terminated parental rights. But there wasn't sufficient evidence for that, or the judge committed a legal error, so you see cases like that. Because of course that's the most serious route where the parental rights are not absolute, but still paramount. And so the courts have to look, very carefully at these factors, because again, absent appeal or some sort of judge error at the bottom, it's now forever, forever gone. Parental rights are forever gone. Yes.
I'm curious about the case that you alluded to 2 minutes ago. Within 24 hours after a voluntary surrender, the client
And that was
recanted that?
Yeah, and that was it wasn't a DCF case, it was an agency. A young girl gave birth, her parents pushed her to have the child adopted. She signed the surrender. And I don't remember how old she was, but she was fairly young. Not so young that she was in high school. I think she might have been first year of college, or 17, 18, like that. Yeah. And we went to court, almost immediately to try to reverse that. We based it on what we based it on, something. Duress, but we really couldn't show duress because it was very careful in terms of the agency. They met with her many times, they advised her, she had parents with her, you know what I'm saying?
She knew what she was doing.
She knew what she was doing. She signed the waiver. Think in terms of defendants waiving, defendants, adult and juvenile alike, waiving constitutional rights. If the court, is satisfied that this was an effective waiver, there's nothing that you can do about it. You can't just go back, oh gee, I should have done that.
Okay, so despite losing rights, you can still be a part of that child's life, like a relationship. No?
In termination.
In termination,
Only if, and again, that's a very small minority of cases, the court orders, and usually with parties having gotten together on this, some sort of post-adoption communication, which could be maybe just, Christmas cards, or maybe an actual visitation. And typically the post-adoption visitation is usually when there's some connection, maybe a relative is in fact adopting. One of my interns was faced with a kind of an unusual issue. She was actually working with an MSL alum that had contacted me, and the clients were a married couple. Father was the paternal uncle, right? The child is 6 years old. Couple has had guardianship of the child since she was an infant. So what happened was DCF took custody, filed a care protection case, but within a month or two later, the couple were there and they were, available. They were relatives. They not only got placement of the child, but with DCF's assent, permanent guardians, DCF then dismissed the care and protection case, because you didn't need it anymore because you had a guardianship in place, okay? Mom was and still is, in and out of rehab, all kinds of issues, had actually other kids after that, and got them back, lost them again recently, all right? Dad is the couple, the uncle's brother, okay? And Dad lives in the same town. He doesn't care. She's all yours. Occasionally sees her, but even when he sees her, there's no, I don't think they've even told her that that's your father. I think they've told her that's, Uncle Bob, for example. So Dad is gonna do voluntary surrender. They want to, when they heard that Mom had recently lost, and Mom really hasn't seen the child, who's now 6, except for when they decided they were gonna take the child on vacation, Mom kind of raised a fuss about the child leaving the state. So there has been a little bit of a connection, but not much. So the couple want to file an adoption petition. We kept going around and around with the statute, because, anyone can say it's a straight adoption through an agency, you're gonna be going pursuant to another section of 210. But we kept coming back to the fact that they need to have a court find this mom unfit, and DCF is still dealing with the mom, but as to the 2 other kids. Do you know what I'm saying? Well, in the end, we determined that even though 210.3 says any person, they decided to file under the regular, so I call it the regular adoption petition, which is, I believe, 210.6, naming the mother and giving her notice. So I'm not sure what's going to happen with that, but she's obviously has the right, because she hasn't lost, they're guardians and have been permanent guardians for 6 years, but she hasn't lost parental rights. So she could contest this, and this could become a 210 type of case, but really without DCF, except for the fact that DCF has her 2 other kids. So the court might be looking to DCF for some sort of report on her fitness, but DCF can't really gauge her fitness towards this child because there's been nothing, no service plans, no ongoing visitation or anything. So it's gonna be weird if she contests in terms of what kind of evidence can the court, gather, actually.
Well, I was just gonna say, a parent can be fit to take care of one child, but be unfit to take care of another.
Absolutely. Richard?
What about going with the not being involved for a certain amount of months during proceeding?
No, absolutely. That, the factors that are certainly against her. Again, except for the fact that no one really, agency or person, has any direct contact with her, that could be, a witness that's, witnesses need to be observable of actual facts, you know what I'm saying? Jadida?
My question is, following a CMP, parental rights are terminated, do the parents have a say, okay, let's say, for example, I could say, I have a sister that can possibly, are they allowed to suggest?
At what stage?
Parental rights have been terminated.
If that far into it, they're gonna suddenly say they have a sister?
Yeah. Would they?
Okay, this wouldn't have happened, because, again, when DCF first either removes children from the home or gets temporary custody, the DCF has to follow its regulations. So if there are, relatives available, that reminds me of a case where DCF really screwed up. DCF placed the kids with a couple that were looking to adopt. DCF workers telling the couple from the beginning, no worry, we're gonna terminate parental rights. The kids are gonna be yours. Kids were like maybe toddlers. We're calling, Mom, mama and daddy from the beginning. Have the kids, the case progress from maybe a year and a half, and
Parents didn't lose rights.
it wasn't the parent. Ultimately, the grandmother got custody. And I'm just trying to remember the sequence of events by which that happened. Because the bio mom had issues. Some of them were health. She had diabetes, but she also was embroiled in a domestic violence relationship, things like that. But the grandmother was never proposed from the beginning, but towards the end she was. But the kids didn't really know the grandmother. So I'm backing up on your question initially. Yes, it can happen, but it was a horrible situation where the children were pretty much like ripped out of the arms of these folks that thought they were their parents.
Now, the foster parents, don't they have a remedy? Don't they have standing to? No. They have
Foster parents have nothing but a contractual relationship with the state. Nothing. Bio parents have rights, the rights that we talked about in your earlier cases. Even if foster parents love the child is bonded with them, again, they have no rights.
So you can
They
say
have no rights.
there's a violation of the contract, contractual agreement, right?
That's all it is.
That's all it is.
Yeah. John?
I was gonna say, where a young parent, in the case you talked about, is kind of being pressured by her parents to give a child up for adoption, is there ever any argument to be made that the parent should get a guardian ad litem, or that they should have any extra protection in that type of a situation?
Right. But unless and until you can prove, duress, or that there was a valid waiver, you can't go any further. You know what I'm saying?
I even just meant that in terms of sometimes we hire attorneys for the children, and we make those attorneys represent what the best, not just the best interests of the child, but what the child wants. Do they ever do anything like that with a 16-year-old?
You can think
mother
about what.
who's also
Yeah,
really
yeah.
tempted to be
If
a
you think
child?
about what the purpose of a guardian ad litem is to step in for a person that, for whatever reason, there's no informed choice. For example, you might have a guardian ad litem for an older, person as well. So yes, that's possible. So these are the adoption cases for Thursday. Believe it or not, it looks like I've given you a ton of adoption cases because parents and children have a right to appeal. Hundreds of appeals every year. Only some of them end up getting reported. And, most with similar issues. Some make sort of new case law. But just like criminal cases, you have the right to appeal, so people appeal. And there were just tons of them, so I pick and choose, what are the leading cases, what are the cases with some sort of interesting factual slant, that we can look at. So we'll go through those on Thursday, and then, what are we doing next week? On a new revised syllabus that.
Isn't it, I'm just using the old one, is it really that different?
Not much. So Thursday we do the cases that start at Hugo and end at Ilona. Next Tuesday we do the cases that start at Linus and end up at Keefe. And then we do the taking of Logan Mar on next Thursday. The week after that, we're going to do a little mock hearing that week.
Could you just repeat that, please?
Oh, okay. This Thursday, Hugo through Ilona. Next Tuesday, Linus through Keefe.
Thank you.
And just one more announcement. You have until tomorrow if you want to go to Billerica House of Correction this Friday. I know, I just got Ash's, again, just voluntary. If you wanna go, let me know. You need to give me your date of birth and, driver's license and the social security. Everybody's been cleared that has.
You need driver's license number 2.
Whoever has already given it to me, you're fine. Everybody's fine. Okay? Everybody's cleared to go. I don't know if you can get out once you get in, no.
It's a little scary. Does this jail have juvenile as well?
No.
No, this is just adults.
Yeah.
There was just,
What
did you
level
see?
is it? What level is it?
It's house of correction, which is not.
Yeah.
Oh,